Who is a testator in estate planning? The testator is a technical legal term for the individual who makes and executes their last will and testament. By way of example, if Janet has a lawyer draft her last will and testament, and she proceeds to execute the will, then Janet is referred to as a testator. When Janet subsequently passes away, she is said to have died testate or with a will. The testator must meet the legal capacity requirements of the governing jurisdiction to create a legally binding and recognized will, which in the province of Alberta is the Wills and Succession Act. The Alberta Wills and Succession Act sets out the legal capacity requirement for an individual to make a will at Section 13. 13 sub 1. An individual who is 18 years of age or older may make, alter, or revoke a will if the individual has the mental capacity to do so. Sub 2. An individual who is under 18 years of age may make, alter, or revoke a will if the individual has the mental capacity to do so, and if the individual A. has or has had a spouse or adult interdependent partner, B. is a member of either a regular force as defined in the National Defence Act Canada or another component of the Canadian Forces, and is at the time of making the will placed on active service under the National Defence Act Canada, or C. is authorized by an order of the court under Section 36. There is also the legal requirement that the will be valid, with the statutory requirements also being set out in the governing jurisdiction's legislation, such as the Alberta Wills and Succession Act at Section 14. 14. To be valid, a will, A. must be in writing, B. must contain a signature of the testator that makes it apparent on the face of the document that the testator intended by signing to give effect to the writing in the document as a testator's will, and C. subject to any order made under Section 37, must be made in accordance with Section 15, 16, or 17. The requirements set on subsection 14C pertains to formal wills, Section 15, holograph wills, Section 16, and military wills, Section 17, with the holograph will having been supplemented by having the will witnessed pursuant to Sections 19 and 20, which is the preferred approach with most wills. With that being said, in each province and foreign jurisdiction, it is important to review the current legislation for that particular jurisdiction and consult with legal counsel admitted to practice in the jurisdiction and made aware of the pertinent facts and circumstances to understand the legal particulars of a testator. For legal services pertaining to wills and estates, from the drafting of legal documents to administering a decedent's estate in the province of Alberta, contact our law firm. Thank you.